Hello, welcome again to the updates that are brought to you by Tanlo Solicitors. My name is Andrew Nyamayaro, and I am a solicitor at Tanlo Solicitors. At our firm, we do practice a number of areas of law, which include immigration, family, employment, wills, probate, business and corporate advice, advice to charities. So we do cover a lot of things that do assist people in various ways. However, today I am here to talk about some questions that I've received in terms of immigration. You can follow us on our channel on YouTube. If you go on YouTube and you look for Tanlo Solicitors, we are available there. You can follow our Facebook page, which is Tanlo Solicitors. And you can also follow my personal profile, Andrew Nyamayaro. So if you do have any questions that you want me to reply today, particularly in relation to immigration, you can either put them in the chat or send them to my WhatsApp number so that I'll be able to reply to them. The WhatsApp number is on the screen. It's scrolling there, so you can get me on the WhatsApp if you've got any questions that you want me to reply. But today, before people start sending their questions, I've got a few questions that I've already received that I need to address. So, as you know, in May 2025, the Home Office introduced a white paper on immigration in which the government promised that they want to take down the numbers of immigrants coming to the UK and those that are already in the UK. So, since then, the government has implemented a lot of changes so that they can reduce net migration to the United Kingdom. Of particular importance to people that have got a sponsor license, the people that employ skilled workers in any area, is that the insurance, the ISH, or rather the ISC, has increased by 32%. That the immigration surcharge, it has skills surcharge has increased by 32% as from the 16th of December 2025. So if you are a sponsor and you're going to sponsor someone, just take note that the increment of the ISC has been effected with over a third of the fee that you were paying. This is a charge that is the responsibility of the employer. So the employer, when they are allocating a certificate of sponsorship, are responsible for two main charges: the certificate of sponsorship charge and the ISC charge. Those are the responsibilities of the employer. Although sometimes it is um, gossiped that people have, or it has been said in the streets that some employers have made their employees to pay the COS fee and the ISC. These are the responsibilities of the employer. The employee on the other side has got the responsibility or can pay their own visa application fee, their solicitor fee, or any other incidental fees that might be incidental to the requirements of their visa. Say, for example, if you are going to do a TB test or you are going to do the English test, then as an employee, you will be responsible for your own fees. However, sometimes it does happen that the employers and the employees enter into contracts whereby the employer will pay for the employee for all these charges. It's quite possible for them to do that. But the bottom line of my presentation on this point is that ISC has been increased by 32% if you're an employer and you are going to either assign new certificate of sponsorships or you are going to apply or extend for people that are already in your organization. Another important point to note is that since the 8th of January 2026, the English requirement is going to increase from B1 to B2 for skilled workers and high potential applicants. So if you are not already in the system with the English that you have, then if you are going to go on the skilled worker, it doesn't matter which skilled worker you're going to go on. It's now B2. It used to be B1 with 4 components. Now it has increased to B2, um, which is a B1 is almost an equivalent of O level, B2 A level, and then C1 degree level, and so forth. So the English is now increased. Another thing that is going to change, especially for dependents, adult dependents, is that they're going to be required to write the English test again. I know a number of people had escaped doing the English test because they were saying it's only the skilled worker, the sponsored employee who do the English test, but it's in the pipeline that all the adult dependents, which includes a spouse, a partner, adult children who are still dependent on the skilled worker, they will be required to do the English test as well. So you might as well start practicing or checking what it entails, because it's most likely going to be implemented as well. Another question that I've been receiving a lot of late is that of people that are switching or extending or changing company. So there are a lot of people that are in the healthcare sector, particularly under visa, SOC code, Standard Occupation Code 6135 and 6136, that are either changing their employers or they are moving or extending their visas and so forth. So there's been a lot of things that has been happening. The first thing that has been happening affecting most people is that there is a lot of delays with the home office systems and processes. So employers are facing delays when it comes to applying for certificate of sponsorships. You make an application for certificate of sponsorship, it will take almost 18 weeks according to the home office. And sometimes towards the 18 weeks, because they don't want to breach their own policy, they will send you an email requesting further information. And even if you are applying for a priority application, you send emails on a daily basis. Not your emails are not being picked and so forth. So the consequence of that is that some people are now getting to the stage of applying for their visas without necessarily having in their hands the sponsorship certificate of sponsorship that they're supposed to have. And if you're in such a situation, you need to review your circumstances to see how best you can proceed, whether it's going to be submitting with a letter or submitting without, and so forth. You will need to get legal advice on the best way to proceed and to cooperate with your employer as the best way to deal with it. Another situation that is arising is for people that, for example, have been dependents or students or another type of visa that want to become carers. So again, the law changed this year that we used to have what were called disposal pools, which are no longer mandatory. So disposal pools are no longer mandatory, although they still exist. But for people that are already in the care visa on the SOC codes 6135 and 6136, if you don't know these codes that I'm talking about and you have got a certificate of sponsorship, if you go on page 2 of your certificate of sponsorship, you will see on which code you have. 6135 used to be code 6145, 6146 is now 6136. So if you are moving from another employer to a new employer, you do not need to do the 3 months. Some employers are saying that you need to do the 3 months. No, if you are already on this 6135, 6136, you don't need to do the 3 months. Only people that are not on these codes need to do the 3 months. So if you're on any other SOC code, 6134, 6131, any other SOC codes, and you want to do care work, then you need to do the 3 months. If you were a dependent or you were a student and so forth, you will then need to do the 3 months that is required. The good thing about this visa, the 6135 and the 6136, is that as we speak now, you don't have to pay for the insurance health surcharge. You enjoy a reduced home office application fee. compared to other visas and so forth. But the challenges I'm saying is that most people are facing challenges with delays of COS being produced by the Home Office, despite the fact that the employers might have applied in time. So there needs to be a strategy between the employer and the employee on how you can deal with this situation. I'm going to go on relationships, and we are having a lot of inquiries in relation to visas which are linked to relationships. Now, some people came as partners, unmarried partners. Some people came as a husband and wife, and some people are thinking or have got married in the United Kingdom and are looking at how best they can proceed. Some are married to skilled workers. Some have found love to British citizens. Some have found love to people that are on refugee status, and some found love to people that are on human rights applications. So, as you'd see, there would be no one-word answer if you are now in a relationship or if you are now separating from someone, because the circumstances are different. So that's where a need of a proper conversation is required between yourself and your representative. If you're having someone who's representing yourself, or you have to do a research for yourself there. So let's start with people that have come in a relationship and things unfortunately have gone wrong. There are some cases whereby people have to, for their own safety or another reasons, maybe they are now victims of domestic violence, or their children are now victims of domestic violence. And remember, domestic violence can be from partner to partner, or child to parent, or parent to child, and so forth. There are different circumstances. Domestic violence can be sexual, monetary, financial, psychological, spiritual, and so forth. So whichever form of violence is there, domestic violence, it can lead people to want to terminate or to remove themselves from harm. So there is a form online where you can complete if you want to remove someone on your papers because of domestic violence. But at the same time, as well, on the same breath, on the same link, if you want to then return, or to, you have maybe made a rushed decision, you acted out of emotions, and you removed your loved one or your partner from your visa, and you want to bring them back, as long as the Home Office has not yet made a decision on the application that would have been made by the sponsor, by the person sponsoring you, there's a possibility that you can still be retained on the visa, as long as the decision is not been made and you've not received a curtailment letter. So we know things do happen in life. You can apply to be retained, but assuming that the Home Office has already made a decision, you will receive a curtailment letter. And with the curtailment letter, you will either have to leave the country or to make a visa application to stay in the UK in accordance to whatever circumstances are applicable to you. So if you have reconciliated with your partner, then you will need to make a spouse visa application as well. As you'd imagine, now we need more evidence to confirm that you are still in a relationship, you have reconciled, the things are good, and so forth. So all those evidence about your relationship, your marriage certificate if you're married, pictures, statements from the two of you, family, etc., and so forth. So all that information becomes relevant. So my point being, if you want to remove someone, as you have received inquiries, yes, you can remove someone from um, your visa as a dependent partner, or if you then decide otherwise, you have reconsidered your position. You acted when you were drunk, or when you were too emotionally high, and now you've come back to your senses. You can make an application to return them to your visa as a dependent as well. Linked to that is things in relation to marriage. As I've said, some people would have been married outside the country, in their home country, whether it's Zimbabwe, South Africa, India, wherever it is. And maybe both of them are in the UK, or one of them is in the UK, and the relationship is broken down. If both of you are in the UK, it is potentially possible for you to get divorced in the UK. So it doesn't matter that you were married abroad, and if both of you are in the UK, there's a possibility. And again, I use the word possibility because it has to be on a case-and-case basis. But in law, it is possible for you to get divorced in the UK. And that divorce certificate or a divorce order is then registered in your home country. So for Zimbabwe, if you get divorced in the UK, the divorce order will have to be registered with the High Court, and then it will be dealt that way. If you have got children, and if you've got properties or finances that are linked, we then apply for a child arrangement order or a child arrangement settlement agreement. We then agree on a financial order or financial agreement, depending on the circumstances as well. So it's possible to deal with the issues either in Zimbabwe or in South Africa or wherever it is, or it's also possible to get divorced in the UK. Either way, that it has got advantages and disadvantages. If, for example, both of you are in the UK and you want to divorce outside the country, then it becomes difficult mostly to deal with. You are not in the country, and serving the person in the UK would require special service and so forth. You then have to instruct a process server in the UK, or sometimes we get instructed by other law firms in Zimbabwe, as an example, to then help them effect the process here. So you need to seek legal advice on that as well. Then there are some people that have overstayed their visas, and a lot of people are getting what is called the immigration bail papers. So if you are on immigration bail, you need to comply with your bail conditions. Most bail conditions of late are now to report remotely. Back in the day, or some people still do, you have to go to a reporting center, to the nearest reporting center in the area that you live or in the region where you live. But now the Home Office has been sending a lot of letters to people so that they can report electronically. So you can report by text, or they can phone you and things like that. So they're just trying to make contact with you, to keep in contact with you, and that's the way that you are reporting. I encourage anyone who is on a need to report, that they have to report, because if you do not report and you then make a visa application, the Home Office might bring that against you, and then they will say that you're in breach of immigration rules, this and that, and so forth. And maybe you are now, for example, you are now in a relationship with someone which is serious, or you've got another reason why you can remain in the UK, they can count the breaches against you. So it's important to report, and it's also important to let someone know that you are on immigration bail in case you are then detained facing deportation. Okay, so another question that I am getting from people is about again the issue of their visa when it comes to ending. So if your visa is about to end and you apply for an extension or a new visa before that visa expires, then at law, your visa is automatically extended by what lawyers will commonly call the Section 3C extension. And I'm sure this is coming to be a common phrase amongst people. So Section 3C, effectively, it covers you when you submit an immigration, and I emphasize the word immigration application to the Home Office or appeal. You are covered automatically by law. It says that you are legal in the country until the day that the Home Office makes a decision. Why I say an immigration decision is because there are some applications that are not of necessity immigration applications, and the common one in the community is the fee waiver. A fee waiver is not an immigration application. It's you pleading with the Home Office that you cannot afford to pay visa applications fees. And the danger when it's used mainly with people that are on a skilled worker visa is that a fee waiver is meant for people that are on human rights. And if you're on a skilled worker visa and you're not on human rights, and the decision is made on the fee waiver decision, refusing you the fee waiver, then your Section 3C extension is affected, from that point when your visa expired, you become an illegal immigrant, which is something that you don't want to be. I know some people have been very lucky to do a section, a fee waiver, and to get an extension of their visa and so forth. And some of them will got it through the disposal pool, which is no longer relevant at the moment. But that is not in accordance to the strict application of the law, because people do advise each other about fee waivers, fee waivers, fee waivers. You need to be very careful when you use the fee waivers if you're a skilled worker. So Section 3C is there to protect you so that you have your continuous period. As we know that the Home Office is proposing that the settlement will move from 5 years to 10 years as a baseline. And then there'll be factors why people can move from the baseline of 10 years upwards or below the 10 years. Say, for example, if you are going to work in the public sector, you still remain in 5 years. If you're a British citizen spouse, 5 years. If you earn 125,000 per year, I think you get a reduction of 7 years. I think if you earn around 50,000, you get a reduction of about 50,000, 5 years again, and so forth. On the other side, if you commit criminal offenses and if you came illegal into the country, if you came illegal into the country and you get asylum, it will take you 30 years to get indefinite leave to remain. If you are on a skilled worker visa as a carer, the proposal is to put you on 15 years. That is the proposal of the government at the moment. So some of these things, it's important to know so that you know what to do in preparation of your settlement to reduce the period that you have to do should they increase it to 10 years. And you have to do some things like becoming integrated into the community. If you're integrated into the community, then that will reduce your period as well. So to things like doing voluntary work, for example, serving in a food bank, maybe serving in your church, and so forth, and the leaders will write a letter for you, etc. So those are the questions that I had on my preparation myself. But I'll just now check if there's any questions in the chat. If you've got any questions, please you can put in the chat, or if you want, you can send them to my WhatsApp number, which is 074 I'll just take a moment to check from my WhatsApp if there is anything that has come through. Checking on my WhatsApp, I don't have any questions that have come to my WhatsApp. And then in the chats. So what happens to a dependent if the COS visa holder dies? It's unfortunate that if someone passes away, the Home Office will ask the remaining partner and the children, if there are any children, to look for a way to remain in the UK. Otherwise, they have to leave the country. So they are given the termination letter, which gives them, or the curtailment letter rather, that gives them the 60 days. And within the 60 days, they either have to find a way of staying in the UK or to leave the country. Now, a challenge that some people in the community will face is if they were a dependent and maybe they don't have any skills, they want to go on the care visa. The first two challenges there. The first challenge being that if they were not already working in the care visa, then they can't sponsor anyone. So if they've got children, they can't sponsor them because they're now switching to the 6135, 6136. And then number two, if they were not already in the care sector, then they might need to do the 3 months. Now, the 3 months is way above the 60 days that they are given by the government to leave the country. So there has to be a strategy. We have been involved in such cases before. There are strategies that we can implement for you to extend the time and so forth. And that it is important for you to then talk to a lawyer or someone who is going to represent you to find alternatives of you staying in the United Kingdom. Who is eligible for a fee waiver? Fee waivers are meant for people that are on the human rights visas. It's not everyone that is meant for a fee waiver. I know that people have used a fee waiver when they're on a skilled worker visa because of desperate times, calls for desperate measures. But some have been successful, some have not been successful. And back in the day when these fee waivers became popular amongst the skilled workers, the Home Office would take nearly 6 months to 12 months to make a decision. And before they made a decision, you get a new COS and then you switch and swap and so forth. But these days, the Home Office seem to have caught that trick, and now they are doing the fee waiver applications very early and very quickly. So you will get a fee waiver sometimes within 3 months or sometimes even less than that. But effectively, a fee waiver is for people that are making applications based on human rights, which could be family, private life, medical, and so forth. So if you can't get a COS and then you're making a fee waiver application, and if the fee waiver application is successful, and then you try to submit a COS application, the Home Office, on its law, strictly interpreted, should refuse that application. But I know applications that have been successful in the past, particularly in the health and social care, because it's an area that the people have been in the disposal pool and so forth because of revocations and cancellations that have been happening to most or to some of the sponsors. Okay, so those are the two questions that I can see now. But thank you so much for joining me. I will be joining you again next week on topics that you want us to discuss. We've got a lot of videos on our YouTube channel. If you look for Tanlaw Solicitors, please subscribe to our YouTube channel. On our Facebook page, Tanlaw Solicitors, or on my personal profile, Andrew Nyamayaro. I do post a lot of things as well and a lot of updates as things happen. And we also post on Zimbo Live, who is our partner as well. So you can see the articles that I do write for Zimbo Live. Thank you so much, and have a good evening.